Hello everyone and welcome to our lecture recording for chapter 29. Today we're going to set the stage for our discussion of criminal law, which is going to happen in the next lecture recording, and we'll cover chapter 30. And today we're going to really set the stage for that criminal law topic by looking at ethics and business practices, and that would eventually lead us to white-collar crimes in the next recording. Alright, so again this is one of the online chapters, and you can download still this chapter if you want to have it in hard copy from the Milo Lab Pearson website. And you'll find that the chapter and objectives start on page 809, and as usual we follow these objectives to go through the content of this chapter. And the first one asks us to recognize the connection between ethics, business and the law. On top of page 810 you'll find the discussion starts by an explanation that the first paragraph, top of the third line, says the law sets the rules that must be followed. Okay. The law sets the rules, and ethics sets the values and standards of conduct which the rules are based on. So if you like, the law flows from the values and conduct standards that prevail in a given society. Okay. Now some points we want to highlight as well is that while ethical business conduct, so values and standards of conduct that would be considered ethical by a given society, while this conduct may impose a cost on business, we want to remember that that cost may be offset by an increase in public confidence. Now, I come from a tradition of law and economics, and the prevailing approach there is what's known as laissez-faire approach, which you'll also find dominant in classical economics and the writings of classical economists such as Adam Smith, that advocate for the idea that a business is able to regulate itself. Okay? And what's good for business is good for everyone. And you find that there are problems with this approach, including collapses of companies such as HIH Insurance and One.tel in the Australian context, and to say that markets can actually regulate themselves would be difficult to pass muster, and that's why we now say that even if a business does not adopt an acceptable ethical standard, you will find that Parliament will intervene and impose such ethical standards. So in Australia, partly motivated by corporate collapses, the Commonwealth Parliament has amended the Corporations Act of 2001, setting new standards for the independence of auditors. You can refer to the Auditor Independence Part 2M.4 Division 3 as an example of that intervention. Alright. Let's continue with our first line objective and talk a bit about law and morality. In terms of something called ethical relativism, we say that the laws are relative to their time and their society. In fact, you could even say that not just laws set by parliaments are relative to their time and their society, but you can even extrapolate this proposition to include religion. So if you look at any religion, you can also say that the laws of that religion are relative to their time and their society. For our purposes, ethical relativism means that what's appropriate at one period in time may not be appropriate to another. Likewise, the law should reflect the attitudes of the society in which it exists, and therefore what's acceptable in one society may not be acceptable in another. Social attitudes then may change over time, resulting in a corresponding change in the law. So it's similar to what we call relativism generally. So there is no absolute truth or absolute ethical standards. These standards function, or they change with the society that we look at for our analysis and the time at which we conduct the analysis. Now, we have talked previously about the idea of what is law. Okay, and this is a good thing to just focus on a bit, because I want to introduce the idea of elements using this definition. Some of you might recognize that this is not the first time that we look at the definition of what law is. And if I take you back to page 5 of your textbook, so this is chapter 1, you'll find that we also have the same definition provided on that page. But let's just look again at this definition and see how we can break it into its elements. Okay? Alright. So we are saying that what is meant by law, okay, is determined really by an individual's moral, political, religious and ethical views, and influenced by the society in which they live. So your understanding of law might be different from other people's understanding of law, whether living in other countries or living in different historical sort of figures that lived in different centuries and different epochs. Let's then focus a bit on this definition. We say again that the law, so our definition, the one we saw on page 5, says that the law is a set of rules developed over a long period of time, regulating people's interactions with each other, and which sets standards of conduct between individuals and other individuals, and between individuals and the government, and which are enforceable through sanction. Now, how can we divide the constituent parts of this definition into its elements? So you'll also find that done for you on page 811. So this is part of the analysis that we conduct on the definition. And the first thing you see that we talk about a set of rules. So our first element is that the law is a set of rules. Okay? So the rules specify what may be done or what may not be done, regardless of whether they are just or not. So justice doesn't come into the picture, doesn't come into the picture when we talk about a set of rules. Then our next element is that this set of rules are developed over a long period of time to do what? So the function of this set of rules, regulating people's interactions. Here we say that the members of society need to know what they can and cannot do. And if there's no clearly understood system regulating the members' conduct, there would be chaos. So while the law regulates the interaction between people, this is important. While we want to regulate the interactions between people, the law cannot anticipate all eventualities because of efficiency arguments. So it costs too much for us to be able to anticipate all eventualities. So we provide just enough so that we can regulate society without having to end up in a chaotic society, and circumstances not covered by the law then will have to be resolved on ethical basis. So ethics in that sense fills the gaps that are left behind by the law. So the law is not going to cover each and every eventuality. Some scenarios, some eventualities are not covered. So how do we then regulate those eventualities that are not covered? How does society does that? How does society do that? So society then comes in and regulates these eventualities through ethical standards. Remember that ethical standards over time will end up also becoming the law, but at certain points in time those ethical standards are simply covering the gaps that are left behind in the legal system. Okay, so we have sets of rules. That's the first element. So the law has to have a set of rules. Anything that we call the law must have a set of rules. Then it also must regulate people's interactions. Okay. And it sets standards of conduct. So how do you regulate those interactions? So that's the third element that I want to talk about here. So we have the law sets standards of conduct. So it sets standards of conduct, and an example of that is something like anti-discrimination legislation, okay, which is stated in general terms and applies widely. The underlying purpose of this legislation, rules or law, is basically eliminating discrimination in all its forms. So in this instance, you find that from an ethical point of view, this law sets the minimum standard that society will tolerate in relation to discrimination. And the last element of our definition is that these sets of rules that regulate people's interactions through setting standards of conduct are enforceable through sanction. So our fourth element is that these sets of rules that regulate people's interactions through setting standards of conduct are enforceable through sanction. Note that the law will impose a penalty or or other sanction to punish and deter non-compliance. And we'll see more of that when we talk about criminal law. However, ethics is a matter for individuals, so it cannot be enforced through sanction unless the ethical standard have become part of the law or the rules of an organization such as a professional body. So the key point then is that a big distinction between law and ethics is that law, which is inspired or derived from our societal ethical standards, is enforceable through sanction. However, those standards from which the law comes are not. Those ethical standards are not enforceable through sanctions unless and until they evolve and they become incorporated into the legal system, such as, for example, anti-discrimination legislation. Let's say a few things about justice, and the discussion here is on page 111. The first thing you want to remember about justice is that it is a difficult term to define. You can also look at the discussion we had earlier about justice on page 7 from chapter 1, where we distinguish between social justice, moral justice, and legal justice. So these don't coincide. Social justice and moral justice and legal justice do not coincide. An example is given to you on page 111. It says the fine for parking in a no parking zone is the same whether you are rich or poor. This may be considered legally and morally just. So we all pay the same fine regardless of how much we can pay. So this is just because everyone is seen to be equal in the eyes of the law. However, it can be seen as inequitable or unfair, as the person who's rich can more easily afford to pay the fine than the person who is poor. So the point here is then, when you look at these different lenses, the social lens, the moral lens, and the legal lens, you'll find that they do not coincide. And what you might find as just under one of them might not be just under the other. And that's why we have a problem with this concept of justice. Justice according to whom? Or according to which standards? Alright. Then we have also an important legal doctrine called the rule of law, which says that laws should conform to a minimum standard of fairness in both content and procedure. Okay, so the rule of law is really intertwined or linked with this idea of fairness, and hence it goes back to our perception of what legal justice is. And this has three propositions. You'll find them starting on page 811. First, no person must be punished except for a breach of the law. Second, on page 812, all persons are equal before the law. And third is that the rights or freedoms of citizens are enforceable in the courts. We will also find that sometimes the moral or ethical standards come into play when we want to distinguish between what we call the letter of the law, so the strict wording of the law, and the spirit of the law, the intention behind the law. Okay. And it's this ethical or moral problem that you have to struggle with in order for you to see, which one should actually trump, which one should be applied. Should we apply the strict wording or the intention behind the law? So again, there is a relationship between law and morality. They are not the same, but they draw on each other, and if you like, they co-evolve with each other. And sometimes you need morality or ethics in order for you to even understand what the law should be. Alright. Let me just take another minute and look at the last part of our first line objective, where we want to emphasize the distinction between morals and ethics. Now, morals are concerned with the distinction between right and wrong. Ethics, on the other hand, which also relates to morals, is on a different scale. So when we talk about morals, it's distinction between right and wrong in relation to an individual. So what your morals are what your values in relation to right and wrong are as an individual. When we talk about ethics, it becomes about the treatment of more questions on a societal base, on the scale of society. So ethics are standards imposed by society. These are external standards. And morals are personal standards internal to the individual. The in brief box on page 812 explains to us that morals are concerned with the distinction between right and wrong. Ethics relate to morals, the treatment of more questions, and acting in a morally correct and honorable way. So those are the ones that become external to you because they are imposed on you by society. But the morals are the ones that are internal to you, that decide what you think is right and wrong. Alright, that's then our first discussion on the first line objective. There's a discussion here about ethical opinions, and these are concerned with the behavior, with establishing ways in which people should behave. So this is again the external standard imposed on us by society. Ethical opinions must be reasoned. So you have to give me a reason why you think something is ethical or not. There must not be mere personal references or preferences. So you can't just say because I believe this is right and this is wrong. Okay? You can't impose your morals directly in order for you to get an ethical opinion. Okay? So self-interest is not an ethical reason for acting. Okay? Appearing to be ethical to enhance the interests of a business, again, is not ethical business conduct. Okay? Usually a business will adopt an ethical approach for two reasons. Either because they're afraid that the market will punish them for unethical behavior, or because they think that eventually governments will legislate to protect consumers, such as what we looked at earlier in relation to the Corporations Act and auditors' independence in the aftermath of spectacular failures such as the collapse of HIH Insurance and One.tel here in Australia. Alright, let's move on then to describing and explaining the main theories of ethics and applying these to some examples from business situations. We've already looked at ethical relativism, but we want to look at how we can, what compass or what test or what criterion or criteria we will apply in order for us to arrive at an ethical opinion. How can we decide, what should, how should people behave? So one way to do that is what's known as consequentialism. So we are going to reason our ethical opinion by looking at the consequences of our actions, of people or people's actions. Okay? So we evaluate the ethical, our ethical opinion about doing something or a certain behavior is found, is decided through looking at the consequences of that behavior. Another way of doing it is through deontological ethics. So this is now on page 813, which is also an action-based theory, just like consequentialism, because in both of these we look at the actions of people. But here, the ethical opinion comes from one's duty, okay, that is determined by reference to consistency and rationality, and not by reference to consequences. So you have a coherent system of thinking and acting, and how that behavior fits into that system of behavior. So you have consistency in the way you approach things in life. Okay. So this comes from actually a German philosopher called Immanuel Kant, and he proposed a standard of morality which he referred to as categorical imperative. So imperative because it establishes principles, so this is how we decide what's ethical or not, based on our principles. And it's categorical because the principles are unconditional, i.e. with no exceptions. The principles that must be obeyed without exceptions. Okay, so that's why it is categorical, the categorical imperative. So these are principles that don't have any exceptions, and based on these principles we can decide whether we have a duty to act in a certain way or not. This is how we decide what's ethical or not. Another approach or theory is known as virtue ethics. This is much older, it goes back all the way to Aristotle. And this is different from the other two because this is not action-based. Now it's focusing on the character of the person behaving in a certain way, the character of the person rather than their action. And you'll find that many will tell us that justice itself is a virtue. And virtue, in a sense, is the mean or the middle point or the mean between two extremes. Okay. This type of ethics then stresses the moral qualities that put us in a position to act morally. It rejects the idea of dealing with moral problems by applying the correct maxim. Instead, it focuses on a person's response to a moral problem as that of a moral person. So you are trying to establish a character that then becomes the compass to what is moral. Okay, or how you would respond morally to a certain problem or a certain situation. On page 1014 we have moral relativism, so just like ethical relativism, so provides that moral values are relative to a particular environment. So the moral values can differ from one culture to another, from one society to another, and from one time to another, and even from one individual to another. Okay. Let's then look at how these theories would apply to certain examples in business situations that would raise ethical issues. Let's look at something called insider trading. So our first ethical issue is insider trading, and we are on page 814. Okay. This is insider trading. Insider trading is an example of what we call white-collar crimes, which we will discuss in further detail later in chapter 30. It is mentioned as an unethical business practice because many people don't see anything wrong with the concept of insider trading. So this is where the morals come in. Your moral compass tells you this is nothing wrong. Okay. So this fact draws attention to the difficulty in establishing ethical business practices because the moral standard says that there's nothing wrong. So internally people think this is okay. externally you're trying to enforce on them something that opposes what they think. Note that insider trading is not an example of taking advantage of a fair business opportunity. The one party has information that isn't known to the other party. The information is obtained solely because of their connection with the company, and knowing that the price of the shares will increase when the information is made public, they act quickly to buy the shares of a person who does not have the information and does not have the means of obtaining it. Okay? So in effect you have stolen the increase in value from the selling party, and this is why we say that this is unethical and why Parliament has made it illegal. So you can see that it's another example of where something seen by society as unethical that eventually translated into, with a lag of course, but eventually translated into a legislative intervention to make it also illegal, not just unethical. Same thing with giving and receiving gifts. Okay, so again, as they say, there is no such thing as a free lunch. You have to decide whether the gift that you are being given a favor by which one day will be called in, or while the gift may be small and on its own a minor matter, it's actually one of many gifts. Okay. So sometimes these gifts could be unethical, but sometimes there would be nothing wrong with that. Okay. So again, there's an example given to you there on page 814. The third ethical issue is the conflict between commercial interests and social utility, meaning that while corporations such as banks and other types of businesses are organizations which must look for profit, so they must create return on investment for the shareholders. All of these businesses are also providing a social utility. So this is utility in the sense that we're looking at the first theory we talked about under the theories of ethics on page 912. So this is utilitarianism. So we see that the consequences of their actions, okay, have also social utility. So they provide a special community need which should be considered in all their decisions. Okay. Another example is also given to you on how that works in relation to the Gulf War and the Oil for Food program, and a company called AWB Limited. I'll leave that for you to look at. And you'll find that there was an intervention called International Trade Integrity Act of 2007 in response to the report of the inquiry into certain Australian companies in relation to the United Nations Oil for Food program. It's called the Coal Inquiry Report. The Commonwealth passed this act in order for us to again make illegal, okay, to make illegal what we knew already was unethical. There's also this practice of conflict of interest. So these are other examples of ethical issues in relation to conflict of interest. So there's a conflict between how you would act towards one party and the interests of the other party that you also represent. Also the idea of unconscionable or unfair contracts and misuse of limited liability of company. So this is hiding behind limited liability in order for you to escape to escape consequences of unethical behavior on your part. And that's why we now have possibilities where we can lift what we call the veil of cooperation or incorporation, so that people like directors, for example, would be found liable, not the company itself, but even the people who work for the company, or the managers or the directors of that company. give an example of that on page 817. And the last one is tax havens or tax evasion. Now remember that everyone endeavors to reduce their tax burden, but some try to eliminate that totally by the use of various tax avoidance schemes and overseas tax havens. Here then we see that this is an unethical behavior because it's self-serving, and ethics is not about self-serving, it's about doing the right thing despite the personal costs. And I'll give an example there, and you've heard probably in the news that even international corporations that don't pay their taxes here in Australia will be hit with a 40% tax when if they're found to have done so. So we are already now taking this unethical behavior which the society frowns upon and turning it into a legal, so the law, i.e. we are now backing it with the ability to enforce sanctions, the ability to punish people for that behavior, and the ability to go after them in the courts. Alright. Let's look at our third then objective, which asks us to identify ethical issues relating to institutionalized wrongdoing and the basis for organization integrity and corporate codes of conduct. So this is on page 817. We have said already that business ethics is about how we conduct our business affairs. It's about individuals and the institutions with which they deal. It's about expectations and requirements, including the social and economic requirements of society. The question, of course, is, can a non-natural person, such as a corporation, have ethical responsibilities given that the legal entity, the corporation, has no character or conscience in the normal sense? So how could you, for example, apply virtue ethics to a corporation? Because it doesn't really have a character itself. And there are questions and examples given to you on page 818 that talk about that even though a corporation does not exist in a physical sense, it still has ethical responsibilities. And we understand why this is the case because of things like the behavior of company directors, which has to have a fiduciary duty towards the company, so a high level of trust between these directors and the company and its shareholders. And this means that you should be held accountable to the ethical opinions or ethical considerations that arise because of conflicts between what these directors want, their self-interest, and the interests of the company. So there are issues such as institutionalized wrongdoing and organization integrity, and I'll leave these for you to look at on pages 818 and 819. The key point under institutionalized wrongdoing is that social forces within the organization might bring pressure on an individual to act in a immoral or unethical way. So the corporation becomes committed to certain course of action, and the individuals who advocated the course of action will often be reluctant to change it, even though ethical problems become apparent as the action progresses. potential danger occurs, the organization will end up going into damage control and will try to cover up knowledge of the warnings, and depending on the nature of the injury, management may totally deny that there is any responsibility on the part of the organization. We've seen this many times before. Oil spills, for example, are a good example of how these companies, big hydrocarbon corporations, deny any wrongdoing in such endeavors to damage control. Power, of course, is once this cover-up commences, one lie then leads to another, which in turn leads to further lies. So further then concealment becomes necessary, and evidence of any previous injuries needed to be destroyed. So they will even go to the extent of even destroying evidence to cover up what actually transpired. In relation to organizational integrity, this is based on self-regulation in accordance with a formal set of guiding principles. So similar to what we said in relation to Kant and in relation to how they talk about that principles that have no exceptions. Of course, that's just the idea that we talked about, the categorical imperative, what he called from the ontological ethics, but that then became operationalized through corporate codes of conduct. Okay, so to ensure that the organization's ethical integrity, to ensure this ethical integrity on the part of the organization, we will have a corporate code of conduct, but remember that this is not sufficient. So you have to have some system to ensure compliance with that code. Okay. There's something called also the corporate culture. So under the crime or the criminal code actually of 1995, this is from the Commonwealth, it refers to something called the conflict between commercial interests and social utility. This recognizes that corporate culture is highly relevant in applying something called the chain of responsibility principle. Okay. So the chain of responsibility means that you can go all the way up to the directors of a company if one of its employees conducted themselves in a way that breaches the social utility that's expected on behalf of this corporation. There's definition also of something called corporate culture. So as an attitude, policy, rule, course of conduct or practice existing within the body corporate, i.e. within the corporation, generally on the part of the body corporate in which the relevant activities take place. The code provides that in bringing an action to extend individual responsibility to the corporation, the following factors must be considered, and those are listed on page 819. Let's then move on to our last learning objective that explains the guidelines for ethical investing and obligations in relation to ethical professional advice. So the first one is that there's something called ethical investing. This is explained on page 120. And it talks about a number of factors that people look at in order for them to ascertain whether investing in a given corporation would be an ethical thing to do or not. Similarly, so I'll leave that for you to have a look at. Similarly, there's this ethical professional advice at the bottom of page 120. Again, this is about analyzing the role and culpability of professional advisors, such as, for example, accountants or lawyers for that matter. Okay, so it considers the way that large corporations might decide to manipulate the court system. And we are given a case study of McCabe and the British American Tobacco Company, or the McCabe case, and this is given to you as a case summary on page 821, and it shows how sometimes corporations will go to the extent of destroying evidence. Okay? Destroying evidence in order for them to prevent the course of justice. So this was part of a discovery process, and how this company decided that they're going to destroy evidence in order for them to prevent the court from finding for the plaintiff. All right, that then brings us to the end of this chapter, and the discussion of McCabe actually continues until page 824. We'll have a much more bigger discussion of that when we look at our lectures or our colloquies. For today, this is the end of our lecture recording, and next time we will start on the last lecture recording, which will cover criminal law in chapter 30.